Good afternoon, everyone. Welcome to Conservatorships, how solo practitioners or attorneys in small firms can expand their practice. This CLE is brought to you by the Committee on Racial and Ethnic Diversity, also known as CRED. The co-chairs are Akram Fazer and Grace Stranch. CRED plans to highlight diverse attorneys with expertise in certain areas of law to the broader TBA membership. This is the first of many CLEs set for this year. I'm Amy Bryant, a member of CRED, and unsurprisingly, I volunteered to present on conservatorships. However, upon further planning for the CLE, we decided to provide information on how conservatorships can be used within one's individual practice or small firm. Since the role of my office in the conservatorship takes place after the conservatorship is established, I decided to bring along someone with superior knowledge and experience in handling conservatorships on every level. So naturally, I invited Travinia Holden. Not only is she knowledgeable about probate law, she is also a small firm owner and has participated in every role an attorney can play in the conservatorship process. So today I will interview Travinia about her practice as it relates to conservatorships, and our plan is to impart nuggets of knowledge that will aid in your practice. So I'll tell you a little bit about myself and then allow Travinia to tell you about herself. I am Amy Bryant, as I said. I'm the director for the Office of Conservatorship Management in Metro Nashville. Our office only services Davidson County. However, the resources and information that we have can be used by individuals across the entire state. At the conclusion of the interview, I'll give you more resources about the Office of Conservatorship Management that you may be able to use. The primary function of the Office of Conservatorship Management is to provide an additional layer of oversight for conservators within Davidson County. So we provide welfare visits and financial reviews and welfare reviews for every conservatorship within Davidson County. To date, Davidson County has about 2,400 conservatorships, which is more than any other county within Tennessee. And thanks to my wonderful staff, we're able to manage the conservatorships within this county. So Travinia, tell us about yourself and your practice and your journey to getting involved with conservatorships.
Okay, well, thank you, Amy. I am so honored to be able to speak on this topic because it's very personal to me. Let me tell you first, I am an elder law attorney. My practice involves all issues pertaining to elder law, including conservatorships. And as you indicated, I have probably served in every capacity as attorney, guardian ad litem, attorney ad litem, attorney of record that conservatorships offer. I also serve as Judge Kennedy's, one of Judge Kennedy's independent conservators, and probably I think I was one of 10 that was initially appointed by him. I think because of your good works in Office of Conservatorship Management, I think you've expanded that group. So we don't get as many cases as we had to. One of the reasons why I was, happy to be asked to talk about this particular topic in terms of how conservatorships, can expand your practice, because that's exactly what happened to me. Conservatorships allowed me to actually launch my own solo practice. And I don't know if you knew that before, but that's how I got started as my solo practice. It was many years ago in Judge Kennedy's court. As a matter of fact, I was actually sitting in court waiting my turn for my case to come up. And I noticed that preceding case, there was an attorney. I don't know if he was acting, I don't recall if he was acting as a guardian ad litem or some other position. I think it was guardian ad litem, but anyway, he was struggling very badly. He was representing the state of Tennessee, the DIDS department, and he could not really answer any of Judge Kennedy's questions. And it was very apparent that he had not done his work in terms of knowing what his duties were in the conservatorship. And so I took that as an initiative, and not that I was trying to throw him under the bus, but I went back to my office that day and called the general counsel of DIDS and said, hey, looks like you need some help, you know, in your office in terms of dealing with conservatorships. And kind of explained to him that I saw, you know, one of your attorneys struggling, and I thought that I could help. And I believe the general counsel at that time was Steve Tepley. And he was like, okay, so you know about conservatorships? And I'm like, sure I do, but I really didn't. So I sent him my resume, what he requested. But one of the things at that time, he made me a contract attorney for DIDS, which meant that they were willing to pay me $750 per case. Now, the law firm that I was working with at the time was like, you know, $750 a case, and they were working on $1 million cases. But the beauty of it is the volume. They gave me so many cases because every case that needed, a prisoner was coming through the state that needed to be declared competent, was given those cases. Every parent whose special needs child was turning 18 got those cases. So, you know, from my colleagues in the firm kind of rolling their eyes when I was like, hey, I'm going to get $750 a case, I was excited. I earned their respect when all of a sudden those cases start going to like $20,000 a month, you know, because of the volume. And so one of the things that I want to impart in terms of how you can expand your practice in conservatorships, I think how that helped me is I became very knowledgeable with conservatorships, learning the ins and outs, because I think the mistake some attorneys make when they are taking on conservatorships or think that it's easy because the statute's in there, when it goes left, and it often does, you've got to know exactly what to do. And you won't know what to do unless you know exactly how conservatorships work. So that's what I'm hoping to do with today, is kind of share those nuggets.
Wonderful. Just in case anyone doesn't know, what is DID?
Oh. Okay, so DID it was the Department of Intellectual Disability Services. That's what they did. You know, it used to be called something else, but it was kind of, it wasn't politically correct. So they changed it to DIDS, but that's what it is.
Okay. And just for anyone who may not know, what is a conservatorship exactly? And how does that come about?
Okay, so let me give you the legal answer first. Okay, and so the legal answer is a conservatorship is a legal relationship created by a court order taking decision-making authority away from a person with a disability and vesting that authority into another person. However, a much more basic definition of what a conservatorship is someone caring enough about someone that has a cognitive disability or that can be easily unduly influenced by another person to protect them from human predators that wish to exploit or take financial advantage of them. That's it in a nutshell.
Okay. So tell us about your practice. What percentage of your practice involves conservatorships, and what roles do you play in this conservatorship process?
Okay, so about 40% of my practice involves some form of conservatorship. And I've served in every capacity in a conservatorship except respondent. And who knows, one day I may be that. And a respondent is the person who you get the conservatorship over, just, you know, for the audience sake. I've been an attorney of record in which I have actually represented conservators that wanted to petition to have a conservatorship placed over another person. I have served as guardian ad litem, which the guardian ad litem is really the eyes and ears of the court, because the judge is ultimately the conservator, even though he or she may appoint someone as conservator over a respondent. ultimately the court is, and the guardian ad litem is the person that's going to go out and investigate the facts of a conservatorship petition, interview the respondent if they can, and to be able to report back to the court whether or not a conservator is needed and whether or not the person who is being proposed as the conservator is the best person to do that. And an attorney ad litem, I've served in that role as well, in that an attorney ad litem is another attorney that is appointed by the court to actually represent a respondent in a conservatorship petition. And usually that individual is fighting against the conservatorship because the respondent has said either they don't want it, they don't need it. And depending on the facts and circumstances is going to depend on that person's role. And as I indicated earlier, I am a conservator. So I have respondents of my own that I'm responsible for in conservatorship matters.
And so you said you've been appointed GAL and you've been appointed AAL, attorney ad litem. How does one get one of those appointments, or how have you gotten those appointments? And is it different in Davidson County versus Wilson County where you are?
I think it is. I think judges have their own methods of, appointments. Some have an alphabetized list of attorneys that have either indicated that they want to be to serve in these roles, and they just kind of go down the list just to make it fair. So not one person is appointed, not one attorney is appointed all of the time. So I think it depends on county. I think it depends on judge as to how guardian ad litems are appointed. Attorney ad litems, I think, are the same, kind of the same ilk in terms of how the judge is going to select that person. I will say even though the statute is discretionary in that the judge can appoint a guardian ad litem, and it used to be pretty routine that as an attorney, especially if the judge knew you and knew that, you knew what you were doing and talking about, that you could ask for a guardian ad litem to be waived. And the judge on your recommendation would normally do that. Now, because there's been so much abuse, with elders, financial abuse in these types of situations, I am finding more judges are just routinely appointing guardians ad litem, period. So in conservatorships, most of the time you will find a lot of times guardian ad litems being, appointed more so than attorney ad litems. Attorney ad litems, again, are probably only going to be appointed if the matter is going to be contested or perceived to be contested.
Got it. And so I'm gonna throw this question out there. I didn't give you this question ahead of time. How do attorney ad litems and guardian ad litems get paid? Because that's the important part.
That's something, and you know what? I'm gonna be very transparent and very candid. Sometimes you don't, most of the time, if this is the type of work that you do and the judge knows that you're willing to take these cases on, they know, if they've appointed you to a case previously and you didn't get paid, they're going to make sure usually the next time they appoint you to a case that you're going to get paid. A lot of times there is some money for you to get paid. It may not be what your normal hourly rate is in your regular practice. But in cases, for me personally, I have taken on many, as you know, where I have not gotten paid. But what I have done is I have asked the court to award or help me get CLE credits. And so that to me is a form of payment, because if I don't have to pay for a CLE and I can get it because of the work that I've done, then that's another way to get paid.
All right, thank you very much. And I want to make sure that everyone out there knows guardian ad litems in juvenile court can be paid through the state, through the AOC. However, there is no similar rule for Supreme Court to pay guardian ad litems in probate cases. And so you can't bill to the state on those cases. So tell us, what's the difference? Everybody may not know. A conservatorship can be tailored or should be tailored to the individual person. So tell us about the different types of conservatorships we have here in Tennessee. If you could just go through the ELFs, the emergencies, and the full conservatorships.
Okay, so let me start with the first statement that you made. In Tennessee, we have a statute that says you should always attempt the least restrictive means, of authority being taken away from an individual under a conservatorship. And what that means is, say for instance, if you have an individual that, they may have a traumatic brain injury, but, they're mobile, they can, walk around, they can communicate, but they're not very good with their money. They just can't pay their bills. They can't, go to the bank and do anything. So in a situation like that, that individual needs help. And so you would ask for a conservatorship over that individual, but it would be where maybe they only need a conservator over their property, which is their financial, but they may be able to get up every day and decide what they want to eat, what they want to put on, what they want to wear, who they want to hang out with, but you only need the control of their money. So you don't need to have a conservatorship over their person, as well as over their property. So the different types of conservatorships, which is your next question, you have what's called an ELF. That's emergency conservatorship that its existence is found under TCA 34-1-133. And an ELF is usually initiated by a hospital for someone that has been hospitalized and is in some sort of either medical crisis or is ready to be released, but is not competent to make decisions for themselves. And they have no one else, no power of attorney, can't find a family member. So usually and this is a relatively new statute in the last, I'll say 5 years or so, I'm not sure. But when it first came out, it was totally confusing, and sometimes it still is. But basically, the major difference between an ELF and a full conservatorship is that it has to be an emergency for that person with a disability. A temporary conservator is appointed for the limited purpose to consent to discharge, transfer, and admissions concerning that person's health care, including financial arrangements if the financial arrangements are going to deal with the health care. And the temporary appointment of a conservator will automatically expire upon 60 days unless it's amended prior to that expiration date. And in these situations, because of its emergency nature, an attorney ad litem is always appointed. They must be appointed to represent the interests of the person with the disability, because a lot of times you can do these ex parte. And so the wards or the respondents' rights must be taken care of with representation through an attorney ad litem. The other thing is with an ELF, a hearing must be held within 5 days of the appointment of the temporary conservator. And within that hearing, it's determined whether or not it's appropriate for that conservatorship to go forward. And usually that's the time that some type of affidavit from physician has, indicated that this person needs, a conservatorship. But the 60 days, and the reason why it's temporary, usually is to be able to get the respondent situated and out of that medical crisis. And if they continue to need the conservatorship, then it is amended to a full conservatorship, which the difference with a full conservatorship is you still have to have a person with a disability. You don't have to have it can't be done ex parte. You don't have to have a hearing within, 5 days. And an attorney ad litem does not necessarily have to be appointed. Usually in a full conservatorship, again, as I stated earlier, depending on the facts and circumstances of that particular case, a guardian ad litem may be appointed. And if that guardian ad litem is appointed by the court, it is the duty of that guardian ad litem to investigate the facts of the petition that has been filed. They will attempt to respond, to communicate with the respondent and explain to the respondent that they have rights. They have the right to appear, they have the right to counsel, etc. And if at that particular point in time, the ward or the respondent says, I don't want this, it is the duty of the guardian ad litem to inform the court, and the court at that point will appoint an attorney ad litem. Now, that is not an automatic, because most of our probate judges are very, astute in being able to know when somebody really needs a conservator that is saying that they don't. And a lot of times, that is a hard position for an attorney ad litem to be in, because you know that your client needs a conservator, but your job is not to throw them under the bus. Your job is to try to defend them as much as possible against having the conservatorship. But the judges are really good about that, and will usually, if the attorney feels strongly and there's medical evidence that this person needs a conservator, 9 times out of 10, a conservator is going to be appointed. The only other difference, I think, with the guardian ad litem in a full conservatorship, they're required by statute to file a written recommendation to the court at least 3 days before a hearing, is set.
And just so everyone knows, since I said ELF, intravenous, also said ELF, and ELF is an expedited limited healthcare fiduciary. Just want to make sure we give out acronyms. We'll let you know what they are. I'll try to remember.
Yeah, because that's a mouthful. And let me say one other thing, Amy. I want to, which we were talking about ELF, and I made gave the reference to the TCA 34-1-133 that really deals with medical. There is another statute, 34-1-132, that deals, it's also when you need to have an emergency conservator or guardian appointed, but that one is not limited to just healthcare. It can be anything that requires a conservator to be appointed as an emergency.
And I just thought of something else to ask you. Does the petitioner have to be the potential conservator?
No, I've had several of those to where, let's say if you have siblings or family members, they want their loved one to have a conservator, but they don't want to be the conservator. And so a lot of times in those situations, what we do is that we will have them serve as the petitioner so we can bring the conservatorship forward, but we will ask the court to appoint a third party conservator so the family member can continue to be a family member, a sibling, a parent, a spouse, whatever, and let the conservator have to do some of the hard, work. So it does.
Got it. And then one thing I just thought about on that note, typically there are hospitals and medical facilities that are filing the petitions for the ELFs. Do you know, and if you don't know, you can just let me know, how individuals are chosen to be ELFs? Is that based on the petitioning hospital or the lawyers that represent those hospitals, or how does that work?
Again, I think it is definitely up to the hospitals. I will tell you, once upon a time, I was doing that too for Vanderbilt. And it's just kind of like how I started my solo practice or my practice dealing with conservatorships. I mean, it's a matter of going and talking to someone and kind of interviewing for a job pretty much. And if they like you, get results, because at the end of the day, the hospital wants their beds. A lot of times these individuals are not paying, just, on the real of it, or they just need them out and they know that they don't have the capacity to sign the paperwork to let themselves out. And so that is my understanding how most of them get their positions, is that, they talk to the hospitals, the facilities, and they're hired to perform that service.
Got it. And so the lawyers that serve as guardian ad litem, attorney ad litem, or ELF, or even the petitioning attorney, is their role complete once that conservatorship is established? Or a better way to answer that, are they automatically released from the case once that conservatorship order is signed by the judge?
It depends on the judge. I will tell you that Judge Kennedy used to make you, stay on cases for the life of the conservatorship. But I don't think he will do that. Now, if you ask to get out, I think he will allow you to get out. And then it depends on the circumstances of, the case. I just want to, because on some of mine, I'm still attorney of record on cases that 10, 12 years ago. And there were some that I automatically, well, let me say this. In answer to your question, no, it's not an automatic thing that the attorney is allowed off of the case once a conservator is appointed. You can ask to allow you to, be complete and to withdraw, from it. One of the things that I do, I always stay on for as long as I think I need to, whether that's 3 months, 6 months, a year, with conservatorship cases, or forever. Like I said, I do have some where I'm still on, because one of the things, and this is a question you're probably going to answer me on my answer, now, but I think one of the responsibilities of an attorney of record is to make sure that your client, the conservator, is doing their job, and that they are understanding the rules, and that they're acting in the best interest of that particular conservator. But I will tell you, in Wilson County, if you go before Chancellor C.K. Smith and you are appointed as a guardian ad litem, you are on that case as a guardian ad litem for the life of that conservatorship. And at first, I didn't understand it until I talked to him, because I'm like, the guardian ad litem? But his rationale kind of makes sense, because he was like, okay, if I don't keep the guardian ad litem on, who's going to check the conservator? And I thought, well, yeah, because the conservator has duties. They've got accountings, they've got annual status reports, they got to act in the best interest. And so, it depends really on the judge. You are not automatically released, but you can get off. And I think it depends also on the type of case that it is.
Okay, then that makes sense. So switching over, after the conservatorship is established, what are some examples of things that are litigated once that conservatorship is established? Or is there any post-litigation once a conservatorship is established?
Yes, and this is kind of where I was saying, you think that you're going along, fine, and then your conservatorship goes left. Because what happens is sometimes a conservator is appointed, but notice was not given to everybody that was an interested party. And so now all of a sudden you've got somebody coming up saying, the person that was appointed should not have been appointed. It should have been me. Or, this conservatorship was actually filed in Tennessee or in this particular county, and it should have been filed in California or in a different county. I've been involved in litigation in both of those types of situations. I think there's always the issue surrounding money. There's always the issue surrounding whether or not the conservator is actually fulfilling their duties, and either mismanaging funds, not taking care of, the respondent. But those are some of the issues, or the more common, issues that are litigated once a conservatorship has been established.
Okay. And I will say, as it relates to Davidson County, our office will file recommendations with the court here. And sometimes there's litigation based on the information that we found, and then the lawyers are brought back in to those cases in order to find a resolution that is in the best interest of the person with the disability. And so what happens if a conservator dies or is no longer able to serve?
Okay, so if a conservator dies, again, there's a statute that talks about termination, of a conservator. Pretty much the court is going to appoint another conservator to act in the best interest of that individual. Usually, once a conservatorship is established, except under very limited circumstances, is it ever a situation where the court is going to say, oh, well, we don't have a conservator anymore, so therefore the conservatorship is terminated? Because if you recall, the basic thing is not about the conservator, it's about the respondent and what's in their best interest. So they're going to still need someone to make those decisions for them. And so it's up to the court to appoint someone. Like, one of the best practices rules that I do is I always, when I am filing a petition for conservatorship, I always like to say I take the belt and suspenders approach and appoint a standby conservator. And a standby conservator comes into play when the conservator dies, can't, is no longer able to serve, or declines to continue to serve. It just makes it easier for you to, motion the court, that, hey, this person, for whatever reason, has declined, died, doesn't want to do it, anymore, hasn't been doing a good job. But we have the standby, person that can do it. And I always do that on the front end in the petition, because if a guardian ad litem is appointed, that person is already vetted. So we don't have to go through that process of the court saying, oh, well, I've got to reappoint a guardian ad litem, or I've got to appoint a guardian ad litem, which is another expense. We can just say, hey, this person was already presented at the beginning of this petition. They're willing to do it. Here's their consent to serve or willingness to serve. And we go from there.
Okay. And so you mentioned best practices, and you've mentioned that you serve as a conservator for individuals. So what are some best practices you've found that work well with managing multiple conservatorships, and any other best practices that you may have as the attorney that files the petition?
For me in my office, when I first started out and didn't have as many conservatorships as I do now, it's good to make sure, from my standpoint as an independent conservator, that you make lines of authority very clear. I always say there's a reason I was appointed as a conservator as opposed to a family member or somebody else, because there's got to be some issue there that the court feels I should be the conservator over someone else. Even though I encourage family relationships, for some reason, there was no family member that qualified to be able to be a conservator. So I want to make sure that we keep those family relationships going. But I also want it to be very clear that I am the one that's making the decisions, and I am the one that is calling the shots, because I am the one that's going to be held accountable by the court. And so if I have a family member that wants to take, the respondent to the doctor or dentist or, somewhere else, I'm okay with that, because I don't have to do it. But I would have already, had a conversation with that doctor, dentist, or other professional, presented them with my letters of conservatorship and court order, and make it very clear to them. Someone else may be bringing them to these appointments, but if there's anything that needs to be signed, if there are any decisions to be made, you got to come through me. I'm the one that's going to be paying the bills. I'm the one that, needs to make sure, because that's the only way that I can maintain control of my duties and make sure that I am meeting my fiduciary responsibilities. And that is even double with, I have several that I pay their bills, so I'm managing their funds. And so even in my office, I am the only one that does that. No one else handles those funds. And then that way, I know exactly where every penny is going. I'm writing every check. I am making sure that I'm paying every bill. I'm not leaving that to a staff member to do. because I don't want any temptations of anybody embezzling funds, which I have an excellent staff and they could do it, but there are just too many horror stories where attorneys have been robbed because we're busy. We're busy, doing everything. And I, again, full transparency, I've been doing this for so long, for some of my conservators. They know, the bill is due on the 1st. They may not necessarily get paid on the 1st, but they know that they're going to get paid. And the only reason why I haven't paid is because I'm busy doing something else. So it's best practices is to make sure that everyone knows that you are the one, the buck stops with you. That, there's no, there's no exception to that. And have I had to admonish, family members and professionals because they either forgot or they thought that they were just going to try and see what I was going to do? Absolutely. But it only happened once and we didn't have to do that, ever again. So that's kind of how I manage. And I will say, last year, I did hire a part-time person because where I used to could go and eyeball all of my conservators one-on-one, I would try to go at least once a month. When COVID hit, that kind of threw everything out of, rank. I've got some wards that are in nursing homes, and so they would shut down and you couldn't go in or whatever. But I hired a client advocate, and her job is I've got a couple that she actually takes to doctor's appointments, dental appointments, and actually goes by and see them. Because my thing, as long as someone in my office or myself, and if it gets to a point where I actually have to step in, I do that. But someone is seeing, touching, talking to my wards. And I think that is the best practices. If you've got to keep lines of communication open in terms of what's going on.
Right. And so I don't remember us talking about this, but are conservators paid? So can a lawyer be paid to be a conservator? And then if so, can the conservator pay themselves? Can the lawyers simply pay themselves whatever that amount is?
Yes, lawyers can be paid. And this is, again, that's another one of those lucrative things I was saying at the beginning, of the program, is that you can get paid and you will get paid and you should get paid. But you can't just pay yourself. As an attorney, you still have to follow the rules of submitting a fee affidavit and getting your fee approved as if you were doing it for anybody else. And so you would submit, your motion, your fee affidavit or your fee application, your order. And once the court signs off on that, if you are in charge of the money, then you can write yourself a check.
Got it. Just want to make sure that's clear.
Yes, absolutely.
What should a lawyer do if they suspect that their client may need a conservatorship, and not a probate case necessarily, but they're representing someone and they suspect that their client may need a conservatorship?
Okay, so now we're kind of wading into that issue, the ethical issue that, those of us that are attorneys that deal with, this on a regular basis, in terms of the capacity of our clients, because, we have an attorney-client privilege that is the foundation of the practice of law. And so it's not like you can go out and say, hey, my client is crazy or they have a mental problem to any and everybody, because you may be violating your attorney-client privilege, or if you have, information about someone. So we struggle with this, on a case-by-case basis, but the Tennessee Supreme Court Rule 8 1.14 deals with a client with diminished capacity. What is an attorney to do? So basically what that rule says, if an attorney suspects that a client has diminished capacity and is at risk of substantial physical, financial, or other harm, the lawyer may take reasonable, necessary protective action, including consulting with individuals or entities that have the ability to protect the client and in appropriate cases to seek a conservator. So that rule, as well as I think it's rule 1.6, will allow you to take some type of protective action on behalf of your client. You know, that may be having to go and talk to the physician, you know, that client's physician, you know, as best you can, to find out really what's going on. But you are still obligated to represent that client. But these are the types of issues where conservatorships can get tricky, and that it is very important that you know all of the rules, you know, around conservatorship, as well as some outside, like the Supreme Court rule, like, you know, rules dealing with, you know, public benefits and other things. Otherwise, you kind of get, you know, residency rules is another, sidetracked on those conservatorships that go left.
Got it. And I know you mentioned earlier that you've served in all of these capacities, and one day you might be a respondent, but let's hope. And so what's the best way to avoid a conservatorship, that steps people can take now, or lawyers can assist people with taking steps to avoid a conservatorship?
I think like the best way for a person to avoid a conservatorship is that they need to pre-plan. They need to do their estate plan, you know, and possibly have a power of attorney, durable powers of attorney for healthcare, durable power, you know, of attorney that's going to deal with everything that's not healthcare. And if they plan that well, you know, then most of the time they're not going to need a conservator. And I really kind of want to be careful by saying that, because just because a person has a power of attorney, that does not mean that that power of attorney is valid. It doesn't mean that because the conservatorship is now contested, that power of attorney may be thrown out by the court. And of course, if it is thrown out by the court, then a conservatorship is going to have to be put in place if the person is a person with a disability. Now, there is a priority statute, you know, that says who can be a conservator in priority order. And the first line of priority is a person that the respondent has said, I want this person to be my conservator in writing. And so again, in my documents, and I think probably at this point in most attorneys' documents, if it's a durable power of attorney, it says, if for whatever reason, this power of attorney is voided or thrown out or whatever, then, and I have to get a conservatorship, then I want the person that I have named to be my power of attorney to be my conservator. And so that's another way that you can kind of, you know, make sure that that happens. And again, even though the statute, it's a priority statute in terms of who can serve, it's discretionary, you know, on the court. The court does not have to honor that, because maybe the person that you put in the power of attorney is not going to act in the best interest, or hasn't acted in that person's best interest under the power of attorney. So quite naturally, the judge is not necessarily going to appoint, you know, that person as the power of attorney. So that to me is the best way to avoid having to have the court appoint a conservator, or have the court appoint a conservator that you don't
Right, right. And before I go in resources provided by the OCM and other resources that lawyers can use before we get into the question and answer portion, is there anything you wanted to say or wrap up that I didn't ask you about?
I wanted to clarify one thing with the standby conservatorship. I wanted to make it clear that even though I talked about needing to have a standby conservator. A standby conservator is not a person that, if you're going on as the conservator, say for instance, you're going on a 2-week cruise, and the standby, well, that may not be an example. Let's say you're going on a vacation, and you say, you know what, I want the standby conservator to, make decisions for me, while I'm gone, or I'm going to run to the store or go to the bank, and I'm going to have the standby conservator just go and be able to write, a check for me because I don't have time. I've got to pick up my kids from school. That is not what a standby conservator is. A standby conservator is only going to come into play when the main conservator can no longer serve. And then the other thing I wanted to mention is about co-conservatorships. I get this question a lot. Should there be co-conservatorships? I am not a big fan of co-conservatorships. I know a lot of times, even when we're doing the POAs, and I have clients when we're doing estate planning, they're wanting to do co-conservatorships. When you're dealing with co-conservatorships, the co's have to agree. They have to be on the same page. If there's signatures that are required, you have to have 2 people actually signing if 2 people have been named as conservator. The only difference with that would be if you've got a conservator over the person and then another person serving as conservator over the property. The only exception that I make with co-conservatorships is when I have parents of a disabled child or a special needs child. Because especially if that child has been disabled since birth, the parents have learned how to compromise and make one decision that's in the best interest. And so usually with those types of situations, I don't have a problem with having a co, but other than that, it can get hairy. And if I have just a minute, I'll just kind of give you an example of a case that I had to where the parents named 2 daughters as co-conservator. The parents lived in one state and then they moved to Tennessee because the father needed to be in an assisted living facility. The father died and the mom wanted to go back to her home state. Well, the daughter that lived in Tennessee did not wish for her to go to that, back to that state. And so there was a big battle going back and forth with this until, and they were still, the mom would spend some time here in Tennessee and would spend some time in the other state. But she herself said, I don't want to be in Tennessee, but she had diminished capacity. And so we had an attorney on the other side. I'm this attorney. Well, to make a long story short, she did go back to the home state, got ill, ended up having to go to the hospital, and she passed away. And I was saying, it's unfortunate that, she had to do that in her senior years, because to me, it would have made sense for her. Obviously, I'm siding with my clients, but just even from a practical standpoint, her memories were back when she lived, in the other state, not when she was here in Tennessee. But because the other daughter was here in Tennessee, she did not wish to give her up. And I was like, well, unfortunately, she died on her own terms in her home state, but it should never have been that. So that's another reason that I don't like couples. So I wanted to clear that up.
Thank you for those clarifications and those examples. If anyone has any questions, you can feel free to put them in the chat while I'm going over these resources that lawyers can use. The first one that I want to make sure you guys are aware of is the Conservatorship Association of Tennessee. It's a nonprofit here that provides resources for conservators, but also for lawyers and other individuals that have that are involved in the conservatorship process. They do have a training video. There are a couple counties in the state of Tennessee that require the Conservatorship Association of Tennessee's training prior to being appointed a conservator in those respective counties. So I wanted to make sure you guys were aware of that. The Office of Conservatorship Management here in Davidson County, like I said before, we have videos, we have written resources, and we have a conservatorship school that is on our website, and that's ocm.nashville.gov. And if you have questions about the conservatorship process or what the fiduciary responsibilities of a conservator are, we've broken those down into about 8 videos that are short, so that you can either use those with your clients or use that for yourself. And our very own Travinia Holden is one of the actresses in several of those videos. The other thing that Travinia mentioned earlier, in Davidson County, we have an independent conservator panel. And I imagine there are judges in other counties that have individuals that they may pull from if they need a conservator. And so here in Davidson County, there is a panel of lawyers, non-lawyers, and organizations that are frequently appointed to cases or appointed to represent individuals that don't have family or friends or anyone else that can make decisions for them. And then someone's appointed from that list. And then the last thing I wanted to make sure lawyers were aware of before we get to these questions that I see coming up in the chat is a pro bono conservatorship initiative that the Legal Aid Society and the Tennessee Bar Association and the Office of Conservatorship Management have put together. It is a function that started here in Davidson County, but if a lawyer is interested in representing a family with an adult child that needs a conservatorship, then you can either reach out to me or you can look at the Public Education Committee's website on the TBA webpage to get further information about that. And we need volunteers in every county, so I would love it if people would volunteer for that role. The other thing that I want to make sure everyone knows, and I tell this to everybody that I meet, we only have one OCM in the state. We really need a statewide OCM or at least OCMs in other counties. Travinia mentioned that one of the judges keeps guardian ad litem's on just so they can monitor the cases, and that's something that we do. And so if any of you have any resources or would like to help me in that endeavor, just let me know. Okay, so we have one question for you, Travinia. It says, what do you do when the ward dies with leftover funds, but no estate opened in probate?
Okay,
no,
so
it's been opened in probate.
Okay, and I think it's going to depend on a couple of things. One, I think it's going to depend on whether or not that ward was a recipient of TennCare, because those funds may belong to the state of Tennessee Bureau of Estate Recovery. That's one thing that you need to, find out. The other thing is the amount of funds that are actually left. You may not have to open up a full probate, but it may be something, if the amount is under $50,000, you can do a small estate affidavit, try to determine if you know who the relatives are, or if who the heirs at law are. If not, you can either put those funds with the clerk of court or file them with unclaimed property. And then, again, depending on the facts, and so you may have to open up an estate and look to the time limit as to, whether or not it's over a year and creditors need to be involved, et cetera, et cetera.
Thank you. The next question is, can you talk a bit about how to proceed with a petition for conservatorship without a sworn physician report in a situation where the petitioner does not have the authority to receive the respondent's medical information at the time of the petition?
Okay, so that is a question that has come up before with a petition for conservatorship about a sworn physician's report. And I get this pushback a lot sometimes from physicians who say, I don't have a notary, so I'm fortunate enough, everybody in my office is a notary, and so I can send a notary out if they're not too far away. Or I have also, if it's a a disability that's not going to change, and the doctor is only willing to, write a letter and swear whatever that this person has, I guess say like cerebral palsy or some type of MR, mental retardation or intellectual disability diagnosis, it's not going to change. I have had, judges be able to say, look, this is the most I can get. This is not going to change. And a lot of times the judges will do that. I've also had attorneys that I've talked to when I've done other seminars say that I think it's Rule 72 where you can do a sworn declaration. I'm not sure so much about that. That is something that we're still looking at, to where under threat of penalty of perjury, the doctor will actually sign, the document when we're not dealing with notaries. But that is an ongoing issue with conservatorships. And I think that if you, do one of those things, either find out whether or not it's a disability is not going to change and try to persuade the court of that, or the guardian ad litem even, or to just be able to present to the court, what it is that you have. Or if you're fortunate to send a notary out, or ask the doctor to do that, sometimes that they will. I prefer a notary, but you do have some other options, and you have to just look at it on a case by case, basis. I'm just not a fan of the Rule 72 because I don't know if the doctor's really signing that.
The next question is for the TBA, actually. Can we send out a copy of today's recording? I believe the answer to that is yes, but I'm not sure. So we will have to get back to you. It may be on the website. We'll get back to you on that. Just put your name if you could put your name in the chat, then I'll make sure that the TBA gets back with you on whether they're sending out a copy of today's recording or how that works. And I'm not sure about that.
I think I just saw another one, Amy, where it's if a conservator wants to add a standby conservator years after the conservatorship was granted, would the proposed standby conservator need to petition the court, or can the primary conservator be the petitioner? I think you're going to need a lawyer to do that. I do not think in any court that I've ever been in where the judge has allowed the conservator, to come in and petition the court. Do you know, Amy?
That's the way it is in Davidson County. A petition for standby conservator is filed. And the same if you want to add a co-conservator after the conservator has been established, you have to file a new petition to appoint a co-conservator.
And that's done by the attorney, right? Not the conservator. Right,
that's done by the attorney.
Right, and one follow-up to that question, it is not, it doesn't matter if it's years, and typically it is with a standby. You can do that at any time because the conservator is going to, be in place for as long as the respondent has a disability and the conservatorship is needed.
Right. Last call for questions. We have 2 minutes. I don't see any others. All right. Thank you very much, Travinia, for doing this today with me. I really appreciate it. Your information advice is wonderful.
Well, thank you. And thank you for all of those that signed on, and hopefully this is helpful. And if anyone, wants to, call me or, have any questions, follow up, please feel free to do that. Okay.
Thank you very much. You all have a wonderful rest of your afternoon.
Bye.
Goodbye.